any conditions until the disposition of the violation. And the only exception would be if the violation is financials only. And therefore, until the VOP hearing, the court can't. Now, if the defendant wishes to go ahead and go forward with the VOP hearing without the, the standard is different. You might want to talk to your client about that if he wants to go forward with the VOP hearing, where the standard is only preponderance of the evidence, not beyond a reasonable doubt. Then we could cue that up. But I'm not sure with the new law in Walton County.
And Judge, I've had that discussion with Mr. Williams at the Okaloosa County Jail. It's not our intention to set this case with subpoenas at this time, given that they are working the case in Walton County. So, thank you for that.
All right, very good.
Carol Willoughby. Judge, this is Carol Willoughby before the court. She is here in 24 CF 2545. This is arraignment on a felony violation of probation, but we have reached an agreement. Any questions for me? So we need to sign it. The agreement that's been reached is for Ms. Willoughby to admit to the violation of probation, be adjudicated guilty. Originally, this was a withhold of adjudication. The agreement is 120 days in the Okaloosa County Jail with credit for time served, $100 VOP fee, $150 cost of defense. May I approach with the plea agreement and score sheet?
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form?
Yes, sir.
And do you understand that you're admitting the violation?
Yes, sir.
And that tells me, yep, Judge, I violated just the way the affidavit report says I did.
Yes, sir.
And do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you were previously adjudicated guilty, I believe.
It was previously a withhold of adjudication. She
Okay,
understands
so
that
she
she's
is
being
going to be adjudicated guilty then.
Correct.
And sentenced to 120 days county jail, credit for time served. Your probation will be revoked and terminated with the additional cost. Is a year enough time to get all your fees and costs to pay
Yes, sir.
after your release? Okay. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
All right, good to go.
This way. Lori Weissac. Judge Jason McKinney on behalf of Lori Weissac. She is here in 23 CF 2268, which is a felony violation of probation. She does have a new misdemeanor, which is part of the basis for the violation. We're going to enter a denial. I would expect motion practice as soon as I'm able to get to my computer. And then we'll ask for the first available court date in March, and we can advance that if we have an earlier court date.
No objection to continuing.
All right. And Madam Clerk, that date would be 3/12 it is. Thank you very much. Good day.
I'll notify Ms. Natali once that motion's filed.
Perfect.
Thank you.
9
Yes.
a.m., no subs.
Judge, may I approach with the stand?
Granted.
Yours.
Did you bring Cochran in?
Are they ready? Who are you starting with?
We got Martinez next.
Okay.
I got it, Mr. Cochran. Judge, this is Mr. William. That's correct. Mr. William Martinez Gonzalez, Thomas Koch, cover for Mr. Cochran. I got 3 case numbers: 2018 CF 2955, 22 CF 2219, and 25 CF 761. If I may just have a brief moment.
Yes, sir.
Judge, this morning we'll be admitting to the violation, previously adjudicated guilty. This is going to be 180 days in the Okaloosa County Jail with credit for all time served. We have $300 for the cost prosecution for all the cases, $300 defense costs, and there's a $50 application fee for the public defender's office, and revoke and terminate probation. All counts and cases are run concurrent. If I may approach with a signed plea form and score sheet.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
Do you understand you're admitting the violation?
Yes, sir.
And that tells me that, yes, I violated my probation the way the affidavit report says it did.
Yes, sir.
And in this case, you'll be adjudicated guilt, and you're waiving your right to a hearing where the state would have to prove that.
Right, yes, sir.
You'll be adjudicated guilty, your probation be revoked and terminated. You'll be assessed the additional fees and costs that were announced. You will be sentenced to 180 days county jail credit for time served. And I'll give you a year to pay all your fines and costs after your release. Mr. Koch answered all your questions about the plea and how it affects you.
Yes, he did, yes, sir.
Satisfied with what he's done for you.
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge.
Thank you. We're going to be standing in for Mr. Cochran for this case, Judge.
All right.
He has a new law in 26 CF 153, which I believe is set on the arraignment docket next week, if I'm correct, Madam Clerk.
Chanel's 26, CF 153.
Correct. And Donell McLean.
Yes, it is on the 219 felony agreement.
And he has today a felony violation of probation arraignment, 25 CF 2033. I'd like to enter a denial in the VOP case and set this over next week with the new law case on 219, if that's a possibility.
All right, so that's 26 CF 153.
Correct. That way, if there is a potential to resolve this matter, then you can make record at that time. In reviewing the case and the current offer from the state, I don't think that that's something that we're going to be able to resolve today, certainly.
Okay.
So I'll pass it over till next week so that Mr. Cochran can enter a plea of not guilty,
All right.
likely into new charges.
All right, very good. All right, thank you, Mr. McLean. Good day.
Next, we have Ruben McKenna.
May I have just a moment, Judge?
Yes, sir.
Mr. Ruben McKenna is here in 25 CF 2316. He's on the docket for a bond hearing in discussions with the state. I believe the state's in agreement with a $2,500 cash or professional bond in this matter.
Correct, Your Honor.
The defense would be acceptable to that in lieu of having the bond hearing. And then if we could make those notations and just leave him on his next scheduled court date.
So 2,500 cash or professional?
Correct.
Yes, Your Honor.
Okay, so ordered. Any conditions?
I would want just monthly in person, weekly by phone reporting.
Monthly in person,
Yes, just once monthly in person and weekly by phone.
weekly and by phone.
Okay. And someone going to tender an order?
Yes, Your Honor.
All right, very good. Thank you.
Next, we have Eric McQueen. McQueen?
Judge, I'll have an order to the court.
All right, thank you. Correct.
What's your name, sir? Just a second, okay? Judge, may I have just a moment? Jason McKinney standing in for Mr. Chris Cochran today. Mr. Cochran is going to be your attorney. Looks like this is an arraignment from a violation of probation, and we'll enter a denial and ask for a court date to be set without subpoenas. I'd ask for the first date in March.
All right, 3/12. All right,
Have you met with Mr. Cochran yet? Okay. He's going to come out and talk to you about the violation of probation. That's his name. He's sick.
Jason. Maybe we'll look at that first.
Next we have Lewis Mueller.
I'll make it. Thank you.
It's just Donell.
I'll check it.
Judge, Mr. Lewis Mueller Jr., 3 case numbers, 25 CF 332, 25 CF 333, 25 CF 345. I'm Thomas Koch, covering for Mr. Cochran. I just may have a brief moment, Your Honor. Judge, Your Honor, Mr. Mueller Jr. will be admitting to the violation this morning. He was previously adjudicated guilty. This will be 180 days in the Okaloosa County Jail with credit for all time served. We have cost prosecution of $300 for all cases, $300 defense costs, and there's a $50 PD application fee. Probation will be revoked and terminated. All cases and counts to run concurrent. If I may approach with a signed plea form and score sheet.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You heard what Mr. Koch said on your behalf and signed the written plea form?
Yes, sir.
You understand that you're, excuse me, that you're admitting the violation?
Yes, sir.
That tells me, yes, I violated the way the affidavit report says I did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
You'll be adjudicated guilty, sentenced to 180 days county jail, credit for time served with the fees and cost. Your probation will be revoked and terminated. Is that what you understood?
Yes, sir.
Is a year enough time to pay your fees and costs after your release?
Yes, sir.
Mr. Koch answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into, accept the plea.
Thank you, Judge. Thank you, Your Honor. You're welcome. Keep that copy.
He's adjudicated, but I think he's previously, wasn't he?
He was.
He's previously adjudicated guilty,
Right.
Judge.
Yep.
Good to go.
Next we have Kelly Midget.
That's fine. May I have just a moment at the podium, Judge?
Yes.
For the court's benefit, she does have a misdemeanor in Crestview. That was part of our discussion. This agreement does not handle that case. So she is going to need to either bond out or handle that case in Crestview. And today, we're handling 22 CF 2562, which is a felony violation of probation. We have reached an agreement. That agreement is for an adjudication of guilt, credit for time served, revoke and terminate probation, $100 VOP fee, $150 cost of defense, send any outstanding costs, I believe a restitution to civil lien. Is that the offer from the state?
It is, Your Honor.
Okay. May I approach with the plea agreement?
Granted.
No objection to this motion.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right. You can put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
You understand you're admitting the violation.
Yes, sir.
And that tells me, yes, I violated the way the affidavit report says I did.
Yes, sir.
And by doing this, you understand you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And this case will be adjudicated guilty, get credit for time served, your probation will be revoked and terminated. The outstanding fees and costs will be sent to, and additionally, the fees and costs charged in this matter will be sent to a civil lien. You can always pay that at any time, and if you wish to have time to pay that, I'll provide that.
Do you want time to pay it?
Yes, please.
So instead of sending it to a civil lien, if I give you a year to get those things paid, is that enough time, you
Yes,
think?
please.
Okay.
Yes, sir.
Usually get on a payment plan with the clerk.
And as long as you're paying, if you need more time, you can ask, and I'll give you more time. If you're not paying, don't ask for more time. Does that make sense?
Yes, sir.
Okay. All right. The court will find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you. Mostly?
Steven Mosley? Hey there. Come on. Judge, Mr. Steven Mosley is before the court in 25 CF 261. It appears in the docket as a bond hearing, even though this is a violation of probation for a misdemeanor. May I proceed forward with the bond hearing?
Yes.
It looks like this is based on a new charge, 26 MM57, in which there is an ROR bond. In this violation of probation, he was being supervised by JCS. It is no bond. May I take some testimony from Mr. Mosley?
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Put your hand down. State your name for the record, sir.
Steven Mosley,
If you were released on bond, where would you be living?
208 Combs Manor, with my mom,
What city is that?
Fort Walton Beach.
Does anybody live there other than your mom?
Yeah, I know his last name. His first name's Adam. It's her boyfriend.
Okay. But you're welcome at that address?
Yes, sir.
Do you know how long she's lived there?
Going on a month.
Okay. How long have you lived in the area?
My whole life, I moved away for 2 years and came back.
And you were on probation with JCS, is that correct? Or Judicial Corrections Services?
Yes, sir.
Okay. Is there anything else you want Judge Stone to know before he makes a decision on whether or not you're going to get a bond or not on the violation of probation?
They took my SSI off, and I couldn't make the payments last year. I'm in the process of getting it back, and I lost my cell phone. I mean, all this was going on about 2 months ago.
If you're out, would you be employed?
Yes, sir.
Doing what?
I'm trying anything I can, probably people ready or anything. I'm trying to get my SSI turned back on immediately, but it's like a little process that they do. I don't know. I've been on it for 8 years.
I have no further questions.
Your Honor, I'm sorry, I should have stepped up before. I have no problem with giving him a bond in this. My biggest concern is getting him to pay restitution on this felony case, and I don't think he's gonna be able to do that if he's in jail, and so, I would.
As part of, I know, as an officer of the court, I would note that he was placed on probation in March of 2025 for a year of probation on the misdemeanor. So I think he may have less than a month of jurisdiction left on probation.
I'd like for him to make as good of an effort as possible to pay as much restitution before that probation is.
So we could always continue this matter in violation of probation, and if he can make some payments.
Yes, sir.
Okay.
right, well, I mean, this is the court's concern. I understand Mr. Mosley's challenges. The probationer failed to pay. He was to report on 10/24 and 12/19 and didn't do so. He was to pay his cost of supervision, but he didn't pay those. He was paid his fees and costs of $420, and he has an outstanding balance of $420. He was to pay his restitution of $827. He did a little better there. He only owes $803. So he paid, what, $24.
I did, can you just,
So,
Yes, sir.
so what's the bond condition you're agreeing to?
I would be okay in this scenario, because I think our biggest issue is we want that restitution paid, and we can't pay it while he's in custody, so I would be okay with doing ROR in this scenario, but I would leave it up to the court as to what conditions to impose. We could do weekly in-person reporting, just to make sure that he is being checked on.
If it, is it going to make a difference in the state's offer to Mr. Mosley if restitution or some amounts are paid?
Yes.
All right, well, I'm not going to put him on pretrial services because he's going to have to report to probation, so that doesn't make sense. But he is in violation status, so those periods are told,
Correct.
right? So as long as they're told, we still have jurisdiction.
Correct.
So I'll give him an ROR. You need to report to JCS as soon as you get out, and you've heard what the state said. They want the restitution paid. You get the restitution paid, they might change their mind about what probation has said. Probation wants you to stay in jail. They want you to stay in jail, but they'd rather have the restitution paid. So if you get the restitution paid, they may change their mind, because it's important to make the victim whole. You get it?
yes, sir.
All right? So what I'm going to do is I'm going to set this for a status on March the 12th. And what I'm expecting on March the 12th is you to walk in with a receipt showing that you've paid some of the restitution. And if that's the case, then we'll move the case forward to give you a chance to take care of business. Okay? If you take care of business, then we'll keep working with you. If you don't, then you're probably going out that door. You got it?
Judge, I'm providing Mr. Cochran's information, and even though he's been on supervision with JCS, I'm giving him the QR code again, and so he has the benefit of that.
This guy's letter all Nichols.
Does the court wish an order in that case?
Yes.
Good morning. Judge, this is Mr. Nichols in 25 CF 2132. I'm Thomas Koch covering for Mr. Cochran. If I may just have a brief moment. Judge, Mr. Cochran has a bond motion set this morning. If I may move forward with that motion and get some testimony from my client.
Yes, sir. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Thank you, Judge. Mr. Nichols, can you state your full name for the record?
Darryl Adrian Nichols,
Okay. Now, if you are released, where will you be living at?
I-850 Lamota's Way, Pensacola, Florida.
Okay.
Or maybe at a shelter, depending on, because I do work for Bird Construction and Fort Long Beach. So my
Okay.
employment's here though.
And we're going to touch base, but you could go back to that 850?
Yes, sir. That's my correct mailing address.
Okay, how long have you lived at that?
All my life.
Okay, and all your life, what does that mean to this court? How many years is that?
Shit, 10 plus, excuse me.
Okay.
Yes, sir.
Now, you said you had employment with Bird Construction?
Yes, sir.
Okay, what do you do for Bird
I'm a
Construction?
concrete finisher.
Okay, and if released, do you still have employment there? You can
Yeah,
start work?
I want to go today. Yes,
Okay.
sir.
How many hours a week are you working at Bird Construction?
Depends on the weather, construction, but top 8 hours or more.
A day?
Yes. yes,
Okay,
sir.
so 40 hours a week, I mean, this is a full-time job?
Yes, sir.
Okay.
Most definitely.
And I just want to briefly touch on your assets, because right now with your charges, it's 20,000 cash and professional.
Yes, sir.
How much money do you have in your bank account?
No,
None?
no, sir.
Okay. Do you have a vehicle?
No, sir.
Do you have any assets?
No, not at the moment.
Okay.
Lost pretty much everything. That's why I need to work.
I guess. No further questions from the defense, Your Honor.
All right, state.
Did you state that you've been living at that address for 10 plus years?
Yes, sir.
Was it you that was living there, or was it somebody else? Were there other people? Is that what you're saying?
Yes, yes, my father stays there too, yeah. Yeah, it's family house. Yes, sir.
I have no further questions.
Yeah, I have no other mailing address, if that's what he's asking.
Yep, you're good, Mr. Nichols. Yes, Your Honor, just to argument briefly. I first want to just notate on his first appearance paperwork, it says his last arrest was back in 2012. Going through the case file Mr. Cochran prepared, I'm just looking at his score sheet, and my client does not score at this time. I see a total sentencing points of 31.3. The nature of these charges, it does have a min-man of 3 years. I just want to point that out. But currently, it's 20,000 cash professional.
So he does score.
Correct. You're right, Judge. Per the min-man as charged, he scores 3 years. Yes, Your Honor. I just want to notate that score sheet, but you are correct. It's 20,000 cash professional. Mr. Nichols gave testimony. He doesn't have any assets. He has stable living. He's lived here all his life, he told this court, and he does have employment on the outside. So we are requesting that 20,000 cash professional to be converted to a signature bond so he can get released, Your Honor.
Your Honor, we would respectfully request that the bond remain in place. We do feel as though this is a reasonable amount for this particular charge in these particular circumstances. Under the bond criteria of 93046, particularly when we're looking at D, I understand the statement that the defendant hasn't had an arrest since 2012. I want to point out that at that time, he went to prison for 5 years and was released in 2017, which is why I was asking about how he had lived at that residence for 10 plus years, considering that he had been released from prison in 2017 for a violent offense, that being false imprisonment, kidnapping. He also had a weapon offense in 2010 before that. So yes, I agree with the defense's position that he hasn't had any arrests since 2012. He was released from incarceration in 2017, and the state doesn't minimize how long that's been from 2017 to now with no arrest. However, I do want to point out that I think it should be apparent to the defendant that he is not to possess firearms. And then once we get to the actual charge itself, we have a situation where when you look at the probable cause affidavit, the officer tells him not to reach in the backpack. He continues reaching into the backpack. He tenses up when officers try to detain him. And then upon looking in the backpack, they find a loaded revolver with the serial number scratched off. With the intent, you then can't locate whether or not that firearm has been stolen or not. I also want to point out the fact that in the probable cause affidavit, he tells law enforcement that they would have to kill him for him to go back to jail. And so we think that the bond amount that's been set, given the defendant's prior incarceration, his prior history of violent offenses, as well as weapon offenses, and then the facts of this case, that a $20,000 bond is more than reasonable given the circumstances surrounding the probable cause affidavit and the defendant's criminal history.
Your Honor, just to briefly respond, Mr. Cochran, of course, is the primary attorney on this. He knows more about the facts. That's why I don't want to discuss the facts of this active case. But I also just want to put out, we are requesting the signature bond and, of course, any other non-monetary obligations this court sees fit as an ankle monitor, weekly reporting. My client, or Mr. Cochran's client, will abide by all those restrictions from the court. Thank you, Judge.
And the min man is on the possession charge, correct?
That's correct, Your Honor.
The weapons charge, because we have two possessions, right? The weapon and the substance, right?
Correct, Judge.
Given the totality of the circumstances in reviewing the dinner proper cause hearing arguments involved, the court would decline to modify the bond conditions.
Yes, Your Honor. Thank you.
Next we have Jorge Peralta with Mr. Hodge.
Judge, it's Mr. Jorge Peralta, Natyappa, in 25 CF 765. If I may have just a brief moment. Judge, this will be an admission this morning. The terms are to admit to the violation. This will be, he's previously adjudicated guilty. We're going to reinstate all original conditions and all original costs. We have the $100 cost prosecution, the $100 in defense costs, and the $50 PD application fee. If I may approach with the signed plea form, Your Honor.
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
All right. You can put your hand down. You heard what Mr. Koch said, and you signed the written plea form?
Yes, sir.
All right. Do you understand you're admitting the violation?
Yes, sir.
And that tells me, Judge, I violated just the way the affidavit report says I did. Is that what you're telling me?
Can you repeat that?
By admitting the violation, I understand you to say, yes, you agree that you violated the way the affidavit report filed by your officer says you did.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
And in this case, you'll be adjudicated guilty. You'll be reinstated to all your original terms and conditions, plus the fees and costs that were assessed. Do you understand?
Yes, Your Honor.
Mr. Koch answered all your questions about the plea and how it affects you,
Yes, Your Honor.
and are you satisfied how you've been represented?
Yes, Your Honor.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you, Judge. If you're going to follow them, you're going to talk to probation, answer any questions.
Your Honor, may I be excused until 1:30, please?
Yes.
Thank you.
Next we have Jason Pulgar.
Oh, yeah, of course. Thank you.
Judge, this is Mr. Jason Pulgar, 24 CF 420. If I may have a brief moment for a signature, Your Honor. Judge, thank you. This is going to be admission this morning. Client was previously adjudicated guilty. This is 180 days in the Okaloosa County Jail with credit for all time served. We have the $100 cost prosecution, $100 defense costs, and there's the $50 PD application fee. Probation will be revoke and terminated. The term revoke and terminate probation, Your Honor, I had to handwrite into this plea form. Myself and my client initialed by that. If I may approach with a signed plea form and score sheet.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, Your Honor.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, Your Honor.
That tells me that you agree you violated the way the affidavit report says you
Yes,
did.
Your Honor.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor.
And in this case, you'll be adjudicated guilty, be sentenced to 180 days county jail, credit for time served. Your probation will be revoked and terminated. You'll have the additional fees and costs that were announced. Is a year enough time to get everything paid?
Yes, Your Honor.
All right. Mr. Koch answered all your questions about the plea and how it affects you.
Yes, Your Honor.
You're satisfied with how he's represented you?
Yes, Your Honor.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
All right, good to go. Take that copy with you. That's your copy. You're welcome. Absolutely.
Your Honor, may you can go 1:30 as well?
Yes, sir.
Next we have Judson Roberts.
Mr. Judson Roberts in 24 CF 2225, Your Honor. Yes, Your Honor, thank you. If, just to get it up to speed, last time we were in court, we had the evaluation, the court ordered that I requested, we received it back. The state attorney is requesting that second eval, and I set it for today for a status just to make sure we're moving in the right direction with that second eval, Your Honor.
Your Honor, at this time, the state's going to dismiss the charge in 24 CF 2225.
So the case is dismissed in 2225.
Yes, sir.
All right?
And Judge, may I just have a brief moment with my client? Just to-
Yes.
Deputy. Thank you, Judge.
You're welcome.
Ronald Roberts.
Judge, it's Mr. Ronald Roberts. We're here in violation of probation on two cases, 25 CF 822, 25 CF 1606, Your Honor. Judge, thank you. We'll be entering a denial on both those cases. My client has another case in front of this court, and that case number is 26 CF 210. These are new charges. We had a pretrial detention last week, but we didn't go forward with that, and we got bond posted. That new case, Your Honor, that 26 CF 210 is set for plea day on March 12th. If I could just have these VOPs march along with that 26 CF case, Your Honor, and ultimately get that pretrial, that's, I believe it's going to be 511 down the road on that new case.
Madam Clerk? Is that when it's set?
Yes, sir, pretrial conference 511.
All right. We'll set this to run with.
Thank you, Judge. We'll speak privately all the day.
Next we have Ashley Rushing.
Judge, this is Miss Ashley Rushing in 25 CF 2364, Your Honor. Judge, my client was arrested back in October 11th on a misdemeanor. Ultimately, a direct issue capias was filed. My client was not served with that direct file capias, even though she was in custody. So this case was set for a status today, so we could get on this docket and she could be served, Your Honor.
All right. And so what do we wish to do? Just a denial?
I was going to ask, can I have a brief moment, because I did get an offer this morning. Judge, we will be entering a no contest plea this morning. The terms of the plea agreement is going to be an adjudication of guilt, 100 days in the Okaloosa County Jail with credit for all time served, $615 in court costs, and there's $150 in defense costs. If I may approach with the signed plea form and a no objection to the score sheet, Your Honor.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. Koch said on your behalf, and you signed the written plea form.
Yes, sir.
And you understand, how old are you?
39.
How much education do you have?
Somewhat. I dropped out in the 9th grade.
Okay, you able to read and understand the plea form? Did you do that before you signed it? Is that yes?
Yes, sir.
Okay. And is what you read in the form what Mr. Koch just announced to me?
Yes.
Do you understand that you're pleading no contest to these charges?
Yes.
That tells me you believe the state could prove your guilt and you're not going to contest it.
Yes. That's right.
And by doing this, you understand you're waiving your right to a trial where the state would have to prove your guilt.
Yes, that's right.
In this case, you'll be adjudicated guilty, sentenced 100 days county jail, credit for all time served with fees and costs that were announced. Is a year enough time to get those things paid?
Yes.
Mr. Koch answered all your questions about the plea and how it affects you.
Say that again?
Has Mr. Koch answered all your questions about the plea and how it affects you?
Yes.
And are you satisfied with what he's done for you?
Yes.
Call to find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge.
Thank you.
Thank you.
You're welcome. Go right to that deputy. Fingerprint.
Next we have Keith Shanklin.
How much time did you? 125. But because I didn't know how much you had. Judge, Mr. Keith Shanklin in 2 case numbers, 25 CF 1839, 25 CF 2467. And if I may have a brief moment. Judge, this will be a plea of no contest this morning. I'll announce these terms. In 25 CF 1839, count 1, and in 25 CF 2467, count 1. This will be an adjudication of guilt, 6 months in the Okaloosa County Jail with credit for time served. I got combined court costs of $1,030, defense costs of $250. And per the terms, we have no return to the CEFCO located at 555 State Road 85, which is located in Niceville, Florida, 32578. And there's going to be $115.07 in restitution to that CEFCO. No return to the grocery outlet located at 1015 E John Sims Parkway East, and that's in Niceville, Florida, 32578. There's $80.84 in restitution to that grocery outlet. All cases and counts are run concurrent, and at the bottom of the plea form, I did include where the restitution is payable to make it easier for everybody. If I may approach with the signed plea form and score sheet.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
Okay, and you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, sir.
How old are you?
52, sir.
How much education do you have?
12th grade.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the form, what Mr. Koch just announced to me.
Yes, sir, what he just read off, sir.
All right, do you understand you're pleading no contest to the announced charges?
Yes, sir.
That tells me you believe the state could prove your guilt, and you're not going to contest that.
Sir?
By pleading no contest, what I understand you to say is that you believe the state could prove your guilt on these charges, and you're not going to contest that.
I'm not contesting them, I'm not.
All right, do you understand by doing this, you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty, and you'll be sentenced to 6 months in the county jail, credit for time served. You'll have the fees and costs that were announced, and the restitution that was announced, and the prohibition against returning to the places that were announced. Is that what you understood?
Yes, sir.
And how much time will you need after you're released from jail to get these things paid?
I'm not sure right now, Your Honor. I'm going through it. My fiancée, she's on hospice, and I don't know right now. I can't say. I can't put a set time on it.
Would 2 years be okay?
Yes, sir.
Okay. And as long as you're making payments, if you need more time, you can ask for more time, but if you're not making payments, don't ask, okay?
Yes, sir. I'm going to ask who will I pay it to, sir?
Say again?
Where will I pay this?
To the clerk?
To the clerk of the court?
Mm-hmm.
Yes, sir.
Now, has Mr. Koch answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
This way, sir. Deontay Smith, next. Deontay Smith.
Judge, this is Mr. Deontay Smith. I have two case numbers, 23 CF 1700 and 24 CF 799.
Yes, sir.
Judge, if I have a brief moment. Judge, this morning, my client will be admitting to the violations of both case numbers. We're going to maintain the withhold. We're going to reinstate all original conditions, all original costs. We are going to modify to add 100 days in the Okaloosa County Jail with credit for time served. This is going to be $200 for the cost prosecution, $200 defense cost, and $50 application fee. All cases and counts to run concurrent. If I may approach with the signed plea form and score sheet.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form?
Yes, Your Honor.
Do you understand that you're admitting the violation?
Yes, Your Honor.
And that tells me that you agree that you violated your probation the way the affidavit report says you did.
Yes, Your Honor.
And by doing this, do you understand you are waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
In this case, adjudication will continue to be withheld. You will be reinstated to all your conditions with all your original costs and fees. And you'll be modified to serve 100 days in the county jail as a condition of your probation, credit for time served with the additional fees and costs. Is that what you understood?
Yes, sir. Yeah.
All right. Mr. Koch answered all your questions about the plea and how it affects you.
Yes, Your Honor.
Satisfied with what he's done for you?
Yes, Your Honor.
All right. Now, I don't know how much credit you have, but As soon as you get out, you need to report to probation, and they're going to give you some instructions about that before you leave today, okay?
Gotcha.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge. Thank you.
Thank you.
Lynn Smith.
This,
Oh, wait, it's only 2 o'clock.
Yes.
Sorry. Brandon Stone.
Judge, this is Mr. Brandon Stone, 25 CF 996 for a violation of probation, Your Honor.
Yes, sir.
Mr. Stone, is there a current offer in Mr. Brandon Stone's?
Yes.
Okay.
The offer is guideline sentence, it's just 15.3 months Department of Corrections.
15.3 months DOC.
Yeah.
At this time, Your Honor, I'm going to enter a denial. I do have an offer I want to discuss privately we just got from the state attorney. If we can get the next without subs, is it, I'm sorry, is there a March date we've been given out?
Yes, sir, there's March 12th and March 19th.
Can we do the March 12th date without subs?
Yes, March 12, no subs.
Okay, excellent. All right, Brandon, we'll talk privately at the jail. Okay.
Next we have SWAT Sill.
What? That's a PTD, isn't it?
Pretrial detentions.
Here, are we finished with the,
That was judge.
I have a couple still on that 9 a.m. docket.
yeah, let's finish it. Huh?
Judge, if I may call a 9 o'clock case, Mr. Jonathan Santiago. Jonathan Santiago in 25 CF 1537.
1537?
Yes, Your Honor.
I don't see that on my docket.
This was added on earlier in the week, Your Honor, I believe Monday, or actually last week.
Do we have Jonathan Santiago here?
Judge, I do have a misdemeanor plea form signed.
Okay. Madam Clerk, you prepared?
Yes, sir.
If I may approach, Your Honor.
Granted.
Counsel 1 and 3 will be go across, leaving the misdemeanor. And it's signed by all parties. And in that plea form, we are stipulating that all time has been served. So this will close the case out. Excellent. And Your Honor, the only other case I had at 9 a.m., it's the last name Smith, first name Flynn.
Flynn Bogart Smith.
Correct. It was on your morning docket by mistake. That's set for this afternoon at 2 o'clock. State Attorney Mr. Little is aware it's at 2 o'clock, and this will be a plea to the bench, Your Honor. That's set at 2 o'clock.
Ah, I see it on the 2 o'clock. So we'll just delete it from this one.
Yes, Your Honor. And that concludes all my 9 o'clock.
That you're aware of.
That I'm aware of. I don't want to speak yet. That I'm aware of.
All right, because did we take care of Pulgar?
We did.
Okay,
With the plea, yes.
that's right. I see. I had it on here twice, and so I see that we did. Don't know sure why. And then I show, with Mr. McKinney, I show Edward Simmons. Mr. McKinney has the look of non-recognition. 22 CF 1180.
Yes, sir. And that normally would not be on my side, that would be an S, and Mr. Koch.
No clue, just it's showing on my docket.
Yes, sir.
Do you show that, Madam Clerk?
Yes, sir.
And it's on for 9 o'clock, Simmons.
Should be you and me, but I don't see it online.
I'm fine.
And I'm showing it's a closed case.
That's right. The person pled to credit for time served back in 2022. I saw that last night. I forgot about that.
And so what I have no idea why it's on the docket. Why is it on the docket?
It's a mystery. I think it's just an inadvertent thing.
Issue of capias.
Yeah. Yeah, that, when I saw that, I thought, oh, it was just a,
I don't know.
Because I show the case is disposed of in 12/15 of '22, but then I see there's an evidentiary VOP on 2/12 of '26.
I think he pled out to 2 counts of POP for just credit for time served, I believe is what happened on that.
What was the first name?
Oh, Simmons.
Edward Dewey Simmons, Jr. Madam Clerk, can you help?
That was, are we talking about 22CF1180?
Yes.
That was what was on the docket, what you just read out,
Okay.
or whatever I saw last night.
That was the best guess that I had, and I don't see another open case for him.
Yeah, I found it. It's numbered on, it does list you as the attorney, Jason.
It probably was me then.
And Brooke Davis is the prosecutor.
I see that.
You did a good job for him.
Thanks.
Did that happen?
Yes.
Good.
Yeah, we're good. Yeah. Yeah, I see a plea agreement for misdemeanors only, time served, no probation, from 12/15/2022.